All right. Thank you everyone for coming to the CVCA Fall Symposium on Therapy in the Courts regarding legal issues in responding to subpoenas and, my apologies, and protecting the confidentiality privilege presented by Dr. Colleen Friend and Seth Goldstein. So for those of you who do not know, my name is Sadie Crow and I am the new project manager for CVCA. I come from working for the Child Abuse Prevention Center for the last about year and a half. I just wanted to go over some quick housekeeping items. As I said, we will be recording this so that it can be viewed later on. And then there will be time at the end of this presentation for some Q&A, but please feel free to drop your questions in the chat throughout the presentation so they do not get missed, and I will make sure to get back to them. So just a brief overview of our agenda today. We will be starting our presentation with Dr. Colleen Friend and Seth L. Goldstein. We will be having a brief 10-minute break in the middle and then coming back to finish off the presentation, followed by some Q&A, and if time allows, some vignettes as well. So now I would like to introduce you to our speakers. So Dr. Colleen Friend is a licensed clinical social worker and is an active professor for the last 20 years at Cal State LA for the School of Social Work. And we also have attorney Seth L. Goldstein, who has worked on litigation involving child abuse intervention for over 34 years and has testified as an expert witness and a trial consultant. I am now going to pass it on to our wonderful speakers to continue this conversation.
You're muted, Colleen.
Thank you. Hi, everybody. Good morning. I wanted to start out with this this first bullet here is our caveat to say that while we're going to be presenting very useful general legal information, it will not take the place of legal advice from your own attorney advising you about a specific situation. Just wanted to say that right off the bat. But the general overview of what we're going to be talking about today includes a range of things from subpoenas to the confidentiality privilege. What kind of a witness might you be? Would you be an expert? Would you be a fact? We're going to get into the rights of children and parents, both at the dependency and the family law court. And then we'll be talking about preparing our clients for possible testimony about them. Okay, next slide. Okay, so I think I'm starting out on this one. And as we go, I might start out and then Seth is going to come in and talk about some specific points. So when you get a subpoena, there's generally two types of subpoenas. One is for the person to appear, and the other one is to produce the records. And there's a Latin term here called ducus tecum. And so those kinds of subpoenas are important to know how to respond to. They're often issued by attorneys, and it has to be properly served unless for some reason the service is waived. But there's a note to consumers that Seth is going to tell us about. So it's important to think about as you receive this document, think about reading it over very carefully and looking at the note to consumers at the bottom.
So if you'd bring up the notice to consumer, when you receive a subpoena, the most important part of looking at it is to make sure that you're properly served. Number one, that it was served personally on you. And number two, that the information that's being requested, if it does, which it invariably will be, asking for records concerning the patient that you've been treating, that is the consumer. Could we see the whole form there? This is what it looks like. And in it should have the name of the person who's making the subpoena or issuing the subpoena. And most important and critical part is that it will, on the back side, show that it has been served on the representative of that individual. That's up at the top, you see on the second page there, or the individual themselves, depending on who it is. If we go back to the first page at the bottom, where it says objection by a non-party to production of records, this is your opportunity to immediately assert any privilege or confidentiality that you believe is invoked by the request for material, which has to do with the therapist-patient privilege or the rape crisis privilege, or any of those kind of privileges which are endemic to the representation or the involvement of children in child abuse. So that's the important part. This you just send back to the person who has issued the subpoena, and that's all you personally need to do. If the party wants to, that is the person who is the records are being sought, wants to object to it, they would file what's called a motion to quash.
Thanks. So, right, coming back to our PowerPoint here, we need to ask ourselves, is what is being requested in terms of records, is it confidential? So in other words, are they therapy records? Are they, records for a juvenile? And just so everybody is aware of this, and I know you know this as clinicians, HIPAA applies, but HIPAA also has exceptions. So what I did want to say to people who are working at an agency, that the client needs to be notified that this is happening. And we would say that it's probably really a good idea, even though you meet weekly with your client in session, you probably want to prepare a written document that this is happening, just so you have evidence that you did discuss it and it was in writing. And the client has certain choices. Do they want you to assert the privilege on their behalf that it's confidential? Some clients might say, no, I want you to give them the records. I want, the court to know exactly what we're going through and what the detail is. So if the client wants the court to have the records, you should also be prepared with a written release that the client signs. You could do this all verbally, but it's probably a really good idea to have a written record of what the client decided on that day, to either release the records, and so they signed the release, or they did want you to go ahead and assert the privilege. So that's really important. And then I wanted, Seth, did you want to say something about the HIPAA exceptions?
Well, HIPAA does have an exception for what's called service of process, or court-related documents. A subpoena is basically an order issued by an attorney, sometimes the court, but mostly attorneys, for you to comply with the request that's being made. So once that's done, that usually satisfies the HIPAA requirement. Now, the thing about a release, and if I can emphasize what Colleen just said, is that you want to make sure that you are protected in terms of any release of information that is confidential by having a signed document that can't be contested at a later time that, well, she didn't misunderstood, or he didn't understand what it was that I wanted, and therefore it was a mistaken release, which of course is liability for you.
Thank you, Seth. So these bottom points we have here is always consult with the attorney that called you. So that might be the county counsel if you're going to dependency court. It could be the district attorney if it's a criminal matter. Or, you also want to consult with your own agency attorney for a specific issue. It's really, and later on in the presentation, we're going to show you exactly why it's important to consult with that attorney. Like, what are they expecting of you? What do they hope to use your testimony to show? And are you on board with that? And what can you say? And also, we'll be saying later on, don't expect the attorney to know what you know. You have specialized knowledge and information. It's very important for you to bring that attorney into that awareness about what you can bring or perhaps not bring to the case. And in family law, there's a code that now allows access to juvenile court records. Seth, did you want to speak on that?
Yes, briefly. The definition of juvenile court records, basically by case law as well as the statutes, is pretty expansive. And you can count on the fact, if you are working within the dependency court, you've been assigned to a case or have a case that's already in litigation in the dependency courts, or perhaps even in the criminal courts, the definition may include the material that you have, not necessarily that it was filed with the court, but that it relates to that particular action that's going on. So you have to be very careful about what you release or what you consider releasing under those circumstances. And that's why it's important to consult with, if it's a dependency case, either county counsel or the lawyer for the child, because and oftentimes they're the ones who are going to make that objection or assert the privilege, or the prosecutor in that case if it's a criminal case. And of course, if you're asking for or they're asking for something in the family law court, definitely you want to consult with your counsel before you release anything to the family court, because family court has not the kind of confidentiality protections in the files that they are making in the official record. And anything that would be involving a child under these circumstances should be done under seal. That's one thing that's really important to emphasize to whomever it is that you're releasing that material to, if indeed that's the end result.
I do want to say I see a lot of good questions coming up, and we will get to them. So we were thinking we'll go through the slides, a couple of the slides first, and then maybe we'll take a pause and get to the questions, because I see, when the questions are relating to subpoenas, you want to have them, answered in close proximity, but we'll get to them. We are tracking them. So thank you. So here we're talking about if you're called to be a witness, so if that subpoena is for you to appear in person, the question is, are you a fact witness or are you an expert witness? And as you can see these definitions here, the key difference is that a fact witness has specific information, but they can't give an opinion about the matter, whereas an expert witness can give an opinion or an interpretation about the facts that are presented based on their expertise from their experience and training. Also, an expert witness is subject to what they call this other term, voir dire, where they really examine your credentials. The attorneys have to agree that you are an expert. And this can be a little bit difficult. So we're going to have a bullet later on to say, what does it feel like when your own credentials are challenged? I like to say, in my own experience, when this has happened to me, I think it's just part of the attorney's job. They're trying to make sure that you really are the expert that you represent yourself to be. And they also want to make sure that if you are giving an opinion, you are actually qualified to give that opinion. So for some experts, there can be some issues about where they want to give an opinion or they believe, where does that begin and end, and where does the trier of the facts, which could be the judge or the jury, make the decision on the ultimate issue. So what I have also found is testifying as an expert, oftentimes I can testify about this child's presentation or statements are consistent with the 30, 50, 70 other children who also present with these symptoms. So sometimes consistent with testimony will work. And you really, as an expert, you have to understand what is the base rate for the problem. So when you're testifying, you can't just say, this child had behavior problems, because almost all children have behavior problems. So that would be too generic, but there might be some specific problems about, for example, for bedwetting. Well, that might be associated with child sexual abuse, but it's also associated with about half of the children, depending on their age range, developmental situation. So you have to understand what the base rate is for the problem that you're testifying about and why that problem might apply to the client that you're testifying about. Seth, did you want to say more about that?
Well, the most important thing about your testimony, either as an expert or otherwise, is to understand what your role is. We all know about the fact that you can't assume two roles. So if you're being asked as a fact witness now to render an opinion, you want to make sure that you're in solid ground, both ethically as well as technically, in terms of what you offer. oftentimes you will be asked both as a fact witness and as an expert to interpret what it is that the child has told you, or what symptoms you've seen, or how you have assembled the basis for your opinion. And that's proper. You just have to be careful and realize that that's perhaps one of the pitfalls that you may fall into.
Thank you. And so this next bullet is sort of reiterates what Seth said. You need to know, where you're going, what the issue is. The attorney who calls you, what they intend to try to establish with your testimony, and really critical. And you'll see this probably about 3 or 4 times. Meet with the attorney beforehand. If you can't physically meet, it might be really important to talk to that person, or even doing what we're doing right now. Sometimes a Zoom meeting can be, as good as meeting in person. Another concept we have here is have your records available. Seth is a believer about bringing the records with you because that helps establish your credibility. Know that could subject your records to also being, looked at and so forth. But it's a good idea to have your records with you because you might want to refresh your memory and really be clear about when certain things happened. When I have testified, I've always taken advantage of the attorney's preparation. Sometimes they give me a timeline, or they help me get more organized about my testimony. And it's very important to be clear about what documents you reviewed and what you haven't. Because when the attorney says, have you reviewed this document? You want to be clear that yes, you have, or no, you have not. And are you familiar with all the exhibits that might be involved in the case? So these are all the reasons why it's important to be familiar with the case and meet with the attorney ahead of time. I think I covered most of that, except the most important thing here is that you may know something more than the attorney knows. For example, they might not know all the features of post-traumatic stress disorder. They don't live in that world. So if your client has symptoms that are consistent with post-traumatic stress disorder, it's very important for you to share that with the attorney so the attorney can use that in his or her preparation for your testimony. Seth, did you have something more you wanted to add?
Just that I think probably, especially with sexual abuse, recantation is a common problem, but most lawyers don't necessarily know that. You can not assume that they understand the process of victimization and the after effects and fallout, if you will, of what happens when the child is either placed back in the home or the pressures that are applied to them. And so that's probably the best example where don't assume that the lawyer knows that when recantation occurs, that it doesn't mean that the child A is lying, or B, that you can't still pursue the case, because there's ample research and studies that talk about the fact that kids do recant after they make allegations of abuse against a parent. Well, I guess I probably should also talk a little bit about the files too. I think one of the most critical parts of bringing your file to court is that a judge or a trier of fact wants to know that you have thoroughly prepared and that you have readily available to you the file for questioning. If you don't bring it, the specter of what are you hiding is raised. And it's just a natural thing on the part of judges in particular, because of the things that they hear all the time, but also trier of fact, if it were a jury, if you're in a criminal case, might be the same. And the important part of bringing your file is, remember, anything you bring into the courtroom and to, in particular, the stand, will be subject to examination by either the judge or the lawyers or both, depending on what the nature of the request is that's in it. So make sure you don't have your notes, personal notes or some other case in there, or other personal notes that have other than what is really required for that file. Next slide.
Great. So this one is on the social psychology of persuasion and impression management. And here, people who are therapists have a tremendous advantage because they understand this. They understand the dynamics of the interaction between you and perhaps the jury or the judge. And so this is sort of your area. And one of the things you might do is, as you look over the facts in the case, you might anticipate some questions and be prepared for that. And you might even practice them. Sometimes Zoom offers you an opportunity where you can actually, look at the camera and see how you're doing and actually do a practice. This one probably you've heard before, dressing professionally. You want to dress in business attire, and that's part of your credibility. When you walk into the courtroom, you do want to make eye contact with the trier of fact, be it the judge or the jury or both, and nod and smile appropriately. And throughout your testimony, you do want to nod and smile appropriately, but you don't want to smile in places where you shouldn't be smiling, where there's very serious gravitas being discussed. It's also easy to say to avoid becoming argumentative, and you can easily slip into argumentativeness by going back and forth and sort of almost sparring with the opposing counsel's attorney. And some of the things that I do when I'm tempted to do that or answer back, or maybe I might have something that I think is a smart answer, I have to ask myself, will this make me look argumentative? So I always stop myself if I think that it might, if there's any chance that it would. But going back up to eye contact and using your ability as a therapist, which you do every day with your clients, connect with them, show them that you understand what it is that they're saying to you. And I think that this is a tremendous advantage for you to look at people and be able to be persuasive while you're stating your point of view. For example, I just want you to think about it. If you think about yourself also as a person, if you were going to be persuaded by someone, could you do it without that person actually looking at you, making eye contact, sort of in the way that I'm doing right now, nodding their head and smiling appropriately? These are really important techniques that you have in your stable of techniques, and it's important that you use them. So before we leave that topic, it's important to listen for the judge's ruling on objections before you attempt to answer. You want to see if it's overruled or sustained, and listen to the questions closely. And I think on this next point, I think Seth had a really important point to make here if an objection is sustained.
So remember, lawyers ask questions that sometimes are not appropriate because of the legal evidence, whatever that may be, that is the objection basis. And so a judge may sustain it. So, for example, if a lawyer asks you a question and the objection is sustained, he's going to ask the same question, but word it differently, wanting the same answer that he got for the first question or she got. So the best example is, and especially as it pertains to the mandatory child abuse reporting law. The standard is a reasonable suspicion raises the requirement to make a report. So the attorney is likely to say, did you believe the child? Now, that's an area that's usually, and for the most part, a total responsibility of the trier of fact. Witnesses can't comment directly on credibility. So what may happen is they'll ask the question. The lawyer will say, did you believe the child? Objection, sustained, whatever, however it's sustained. The lawyer is likely to ask the next question of, well, did you have any reason to doubt what she told you? He's asking the same question, only it's a different way. The answer can be a yes or no, and then they'll ask for some elaboration. But you have to remember what the first question was before that.
Okay, can we see the next slide? Great. So some principles of expert testimony. So we're recapping a little bit of what we said earlier. Who's an expert? Well, this is someone who has special knowledge that the trier of fact does not. And their purpose could also be to educate the trier of fact. And there are some differences about triers of fact, and we'll get to that when we talk a little bit about dependency law versus family law, and criminal law. But one of the acronyms we have for expert testimony, and you might consider remembering this, is the HELP. So the first, you're going to be sworn in, you're going to be promising to tell the truth, the whole truth, and you're going to show that you're even-handed. So you want to give not only the truth, but also the appearance of actual fairness. And that may be that you have to concede that your case has some weak points. And this would be a really good idea to go over with the attorney ahead of time so he or she is not surprised by this. And it's important that, you know, you acknowledge that when the opposing counsel asks you about it. Then you have to also acknowledge the limits of your expertise. What went into forming your opinion? Can you explain it? Sometimes you're citing academic references or journals or books that you've read. It can be some special training that you've had, or you might also be referencing the number of clients that you've seen that are very similar to this particular issue and client. So as Seth said earlier, preparation and mastering of the facts is very important, and important to meet with your attorney ahead of time, or the person that called you to the stand, so that you are actually on the same team. So Seth, did you want to say something about letting the attorney know the weakness or the what you call the bad facts in the case?
Yes, thank you. I think it's really important for you who are as close to the literal facts as you are to alert the attorney if you believe that there are anything or any things that are the kind of impeachment material that might come up, that is something that would contradict either something you testify about, or something the child testifies about, or something that the parent testifies about, excuse me, or things that you think are maybe peripheral, in the sense that they are things that went on outside of the actual therapy session that you had, but that you've learned that may be harmful for the case. And the lawyer should know in advance, so that if such a thing happens, they can deal with it. Or more importantly, if the weakness is such that it's something that you just need to alert the jury to with an explanation, the lawyer who's presenting that evidence will want to put that on first. And in having a discussion with you about this ahead of time, the two of you can understand what's the best way to present this evidence.
Thanks. And the last bullet down here, I wanted to speak a little bit about this, because sometimes when your credentials or your opinions are challenged in court, sometimes it feels very personal. And I wanted to speak to the fact that it's easy to say this is just the attorney's job. He or she has to represent their client in the best light that they can. And especially if they have weaknesses in their own case, they may be particularly aggressive with trying to challenge your opinions. And sometimes this can feel unsettling for you. So we wanted you to be prepared for this when you go to court. And some attorneys are more aggressive than others, and some are less. So it's hard to know what's going to happen when this happens. But one of the things that comes up is I keep reminding myself, this is part of their job. This is why they're here. This is part of the process. And Seth, you had something that came up for you when we were preparing for this that you wanted to share with our audience today.
Well,
Your so what thing?
Oh, yes, thank you.
Yes.
So what I tell my clients when they're testifying, or the witnesses, if they feel that they're personally attacked, or they feel that it's a bad fact, just matter-of-factly, without emotion, without any emphasis, answer the question, and then to yourself say, so what?
That can be helpful. But we don't want to minimize the fact that this can feel very challenging, and it could be one of the reasons why you guys wanted to have this training today. You know, it can be. So that sometimes it's important to rehearse. Would you say, Seth, that that's a good idea to rehearse?
Well, I'm not so
attorney.
Use the word rehearse, but you certainly want to go through rehearsing has a negative connotation. Remember that anything that you have done with the attorney who's calling you, because that's not your attorney, is not privileged. So the questions will be, well, what did you do to prepare for today? Did you rehearse your testimony with the lawyer who called you? Did he tell you what he wants you to say? The answer to those questions are obviously, yes, I discussed the matter with the attorney, and we talked about what my testimony would be. And that's really what you want to make sure that you know is, what is it they're going to ask you? For two reasons. Number one, so that you can tell the lawyer, well, you know, that answer you're looking for may not be so helpful, because here's the counter evidence. And if I'm asked that question by the other side, this is what I would have to say. Or the question that they're asking doesn't go far enough. We all know that, especially in child abuse, there are a lot of counterintuitive things that children do and that parents do in terms of trying to protect what's going on. To protect the child and what's going on with the child, and what the offending parent would do as well. So depending on what side of the equation that you're on. So it's real important for you to be able to understand and know what questions are coming to you, so that when the lawyer asks you a question, you're not giving an answer to something else that A, wasn't what he really asked, and B, ends up being harmful to the case. Next slide, please.
Yes. So this slide on depositions, they're often used in, excuse me, in civil proceedings, and this is a part of discovery. The witnesses are sworn in. There's no judge present, but you are sworn to do everything you need to do under oath. And a lot of the same questions come into the deposition from the previous slide. So there is a voir dire and a challenging of perhaps your credentials and your opinions. And the purpose is to learn and limit the opinions that the expert would render at court, and to determine the basis of your opinion. So you must prepare. So I thought of an example. I know that when I was in a deposition, one of the issues was, did what the child had said, did that constitute a disclosure? And my opinion was that it did constitute a disclosure, and that was a very big issue there. And I was able to say that I thought it constituted a disclosure because in my previous experience in a certain position that I had supervised over 1,100 cases where there had been disclosures, and that I had done certainly at least 50 to 60 interviews where there had been disclosures. So that back in a certain time period, in 1989, this certainly would have been considered a disclosure. And that was germane to the issue because the kid's disclosure was back in 1989. So those are the kinds of things that come up both in court and in depositions. And it's important to keep in mind that what you testify to in the deposition really can't be changed when you go to court unless there is some notice given. Seth, did you want to say something about that?
Well, the most important part about that is you want to be sure that you're adequately prepared for the questions that are going to be asked of you, because if you do testify in some different way at court, that's impeachment. That's an inconsistent statement. And the question becomes, why did you make that change? Now, there are many reasons that may happen, and you can explain them, but it's important for you to do that. You will get a copy of the transcript after the transcript has been prepared, and you need to go through it and make sure that the person who did the transcription accurately and adequately reported what it is you said. Now, that sometimes happens. Well, what often happens is the court reporter, because remember, they don't actually put down the full word that you're testifying about or saying. What they do is they put down symbols that are supposed to, in some way, remind them as to what that word was. And oftentimes they'll use a different word than what you said. Those are really critical because sometimes those are the operative terms, the verb, the object, whatever it may be, that is so critical to your testimony. And you'll have an opportunity then to review the material, note where the corrections should be and what the right words are, and then sign it and return it to the I guess it would be the court reporter in this case. And it's critical that you do that within a 30-day period. If you prolong that and go beyond it, any objection or changes are waived. Oh, by the way, the other thing too is, remember, one of the reasons that people do depositions with experts as well as other witnesses is they want to see how this person is going to testify. So it's important that your demeanor, all the things that we've talked about thus far, is professional, and not argumentative, not defensive, that you are well-versed in the facts, so that if it's the person who's calling who is on the other side of the case, this is your opportunity to be able to assure them that you're going to come in and you're going to nail the case, and that they shouldn't actually call you as a witness, because to put you on is going to be harmful for them.
All great points. And I like the fact that Seth used this word demeanor. They are looking at your demeanor. And so it's a good chance for them to get a heads up on your demeanor. So
And
it's very important to be prepared and to act the same way that we talked about on the previous slides. Were you saying something, Seth? Did I want to?
yes, and this is the opportunity for them to test it. They may try to push your buttons, and it's real important for you to be able to remain in control.
Yeah. And Seth, you brought up a really good point about looking at the transcript after, because I've been in several depositions where I really had to pay attention to the transcript after and make some serious corrections that I couldn't understand how they got that word, but it could be because the stenotypist is doing the best they can to recreate what they think that you said, and it may not be the right thing, and it's important to correct it. And all this takes time. So I can see that many of you, we're talking about, it's a very time consuming thing. So important in it, but it has to be done accurately, because the outcomes are very important. Okay, how about the next slide? Okay, so thinking about, do you want to raise the confidentiality privilege? It may not be raised for every single subpoena or request for records that you get. So this is recapping what we said before. You want to discuss it with the client. Remember, we said, go in and just meet face-to-face with the client, but also have some papers prepared that they're actually aware that there was a subpoena and what the issue is, and whether or not they want you to raise the privilege on their behalf, or whether or not they want you to release the information. And you should obtain a signed release if that is so, if they want you to release it. And just reiterating that the privilege belongs to the client, but it's asserted by us unless the client waives it. And you can assert it. There's no guarantee it will be honored, but judges have a certain amount of respect for confidentiality, but you can't really guarantee the outcome, but it could actually be honored. Seth, did you want to say something more about that?
Well, thank you. The confidentiality has some absolutes and some maybes. If you ever talk to an attorney and they say it depends, well, that's one of these cases. Most of the time, an attorney-client privilege is sacrosanct, and that's very seldom, although if you listen to the news right now and certain things going on in Washington, D.C., there is a question about that, but that doesn't happen very often. So the evasion of the therapist-patient privilege is almost as sacrosanct. And I say almost because there are some circumstances where that may end up being something that is you can get into, in particular, if it's a child abuse report. So if you've completed the SCAR, mandatory child abuse reporting form, or made a report and the social worker has written a report and quoted what you said, those statements are not privileged. And there's a reason for them not being privileged, and that's so you can make the report, but also for the ability to know what the exact claim is, because those things are discoverable.
And then I think we didn't quite get to this one yet. If you give an answer in court and it does invade your communication with the client, you must answer it by stating that the question requires privileged information. Did you want to say anything more about that, Seth?
Yes, you can state it exactly as Colleen has just mentioned, or you can say, I can't answer that question because it is privileged. The question then becomes whether the judge will either order you to either testify about what it is or have a conference with counsel and yourself out of the presence of the jury if it's a jury trial, or if it's the trial by judge, bench trial, the same thing would happen, but he would end up excluding that information were it to be something that went beyond perhaps what would be normal and proper to hear.
And this last bullet I inserted here because I thought to myself, if many of you probably incorporate a lot of things about this into your intake procedure. But if some of this is news to you, you might want to redesign your intake procedure so that your informed consent helps our clients understand the risk that might be involved here. Like they might think they're coming to your agency, that they're finally going to be heard, and this is all going to be confidential. And then boom, a subpoena shows up. So it's really important in the very beginning of your relationship that you say to them, what are the limits of confidentiality? You know, you absolutely go through that you're a mandated reporter, but you also might want to say, you know, there are certain circumstances that this information may need to be disclosed at court, either through record or through a therapist testimony. And just wanted to make sure that you understand that that's a possibility. And I think if you do that early on, you get some informed consent from the client and they understand what could be going on. It's just probably you already do that, but if it's not part of your intake process, it probably should be and could be very easily added.
If I may add, Colleen, there's one other aspect of this, and this, what I think is critical in terms of consulting, not just with the policy or your supervisor or administrator, but consulting with an attorney as to whether or not this information is confidential and how that you or they want you to assert it. I've testified both as an expert on what is confidential in terms of juvenile court records, and I've represented therapists and professionals under the same kind of circumstances and answer those questions. And it's something that comes up all the time. So don't hesitate, especially when there's that issue of ethically violating that privilege and potential complaints that might be made or lawsuit. You want to make sure you have sound legal grounds to do what it is that you're about to do. I think we want next slide.
I think we should go to the next one. Yeah. So I'm wondering, Seth, if before we go to the rights of children and parents and dependency, I wonder if we should stop because I saw a couple of really good questions in the chat that have to do with subpoenas. We're coming away from subpoenas now, I think, and talking about other things about the actual court. So I wonder if we could, is that okay with everyone if we stop and take some of the questions that have come up so far? So I'll rely on Sadie and Michael to tell us what questions we should be responding to.
Yeah, so let's go to just the first question. Let's see. So Selena asked, does it have to go to the actual person or to the agency? And that was regarding at the very beginning.
Well, that depends on what the subpoena is asking for. If it's only asking for records, it should be going to what's considered the the custodian of records, another C word. So yes, that's a good question to know. If it's for you personally, there are two kinds of subpoenas. There's one where they just want your records, and it'll have your name on it, but it'll say they want your records. And many of you are in sole practice. You may not work for an agency and don't have a consumer of records. So the consumer of records is likely to be you. So in that regard, again, it has to be personally served, A, and B, it has to properly name the person or entity that it's asking the records for. And then the date for production has to be within the right time frame, and there's a whole bunch of things that go along with that. But essentially, the subpoena should identify A, if it's an individual, or B, if it's an individual and the records, or C, it's just the records, produce them at this time. And there is a provision for you to just produce the records in a sealed envelope, sending it to either the deposition officer or to court, depending on which subpoena you get. There are two kinds of subpoenas. I guess we should have mentioned that before. One is called a deposition subpoena for records, and that may be asking for both personal appearance and the records, or just the records themselves. And the declaration, there is no declaration that's required for that. In a subpoena ducis tecum, that's a totally separate one, and that's only to the court, to bring the records to the court. And there'll be a declaration within the document itself that says why I want these records, what's material, and the reasons why these records are essential for proving a material fact. And there's one other question which I forgot at the top of my head, but the most important part is that they have to, on the face of the subpoena, explain what the relevance is, what's the legal authority to ask for it, and what subject it goes to.
Perfect. And Roger's asking, regarding consultation with an attorney, we have a policy to not even confirm or deny that a person is a client without a signed ROI. Are there exceptions in cases of family law?
Well, I can't think of any exception where if you have a therapist-patient privilege or just the relationship, which should be confidential, that's a perfectly appropriate answer to give until you do get that release of information.
Selena is asking for files. Does that include paper files and or electronic files?
Yes, it does. And there are specific requirements that pertain to what we call electronic ESI, electronically stored information. And the subpoena generally will tell you what it is they're looking for. It'll include a definition of ESI, and it will ask for the manner in which to produce it. Since we're talking about ESI, the way that you're supposed to produce that is in its original form. So if you got it in a PDF, you send it in a PDF. If you got it in a JPEG, you send it in a JPEG. That kind of thing.
And to what extent can a therapist agency bill for their time for prep, deposition, consultation with the attorney, etc.? If so, who do you bill?
That's the second most important part of this.
Go ahead.
So yes, I think that's a very legitimate question and often comes up. So the way a deposition works, as in a trial, is the person who is calling you to testify pays you for the time for testimony. As far as the deposition preparation, that goes and should be billed to the client to whom you are working for, or the lawyer who you're working for or working with.
And to be clear, a judge can order a therapist to break client privilege without client consent.
Can I go back to that last question for just a second? It occurred to me as another aspect. If you're being called as an expert witness, if the check for your testimony is not in your hand before you testify, you don't have to go. Statute is very clear that the expert must be paid at or before the time of the anticipated testimony. Now, the next question was having to do with what can a judge make that order? Well, there's a joke I've heard that I probably shouldn't tell, but I will anyway. And it, I think, illustrates this very well. There are a bunch of people waiting at the pearly gates, and there's a guard who's basically sleeping on that spear. Time goes on, and all of a sudden the gates flash open, and a guy in a black robe runs right out of the gate. And as they're standing there, they're all, what was that? What happened? Nobody's ever gone in. Nobody's ever come out. And somebody gets up the gumption to ask the guard, who was that? Oh, he says, that's God. He thinks he's a judge. So the important part is, remember, they are the people who make the rule. They are the one who, when you're in that courtroom, you can assert the privilege. You can tell them that it's not proper. And that's proper to do because that protects you. But if the court orders you to say something, you better do it.
If a lawyer calls and is asking on behalf of the parents for records for their own review, this is for their child who is in therapy, what is the therapist and the agency's role around confidentiality as it pertains to releasing these records?
So as I understand the question, I think what you're saying, Sadie, I don't see it in the chat, but if a lawyer for parents asks for a child's record, so the parents own the privilege for the child. That is true. But let's bring Seth into that. Say the parents have an attorney and the attorney calls the agency and say, I want Johnny's records. I represent the Smiths and I want Johnny's records.
This is a constant issue for people who are involved in child abuse cases. First of all, there are two issues here. One is who has legal custody, and the other is who holds the privilege. So if there's a litigation ensuing and hasn't started yet, you have to determine your client is either represented by themselves in terms of their ability to assert that privilege. And as we know, under the Health and Safety Code, I forgot the section, but if you as a therapist believe that releasing that record is or information is going to be harmful to the child, you can prevent that from being released without a court order. As to the legal stance of the parent, a parent who has joint legal custody can ask for records or anything that has to do with the information that pertains to what's going on with the child. There's a code section within the family code that says that a parent, regardless of their custody rights, has the right to information about that. And so the custody legalities are in somewhat questionable depending on what case you have. And that's why it's important to find that out. The lawyer calls you and says, I want this information. What you need to be asking them is, who has legal custody? Can you show me the document that approves that this is available to that individual, number one. And number two, to what extent are they entitled to the information that's there? And that has to do with you're protecting your client either because you're afraid of the consequences of releasing that information or for some other reason. And we know that children who are in therapy, especially for abuse, are very concerned about what the other parent might know or what their parents might know. And that can be very harmful, as we've seen, unfortunately, where kids end up committing suicide as a result of the release of that information. So it's that's a critical factor. That's one of those answers that you have to say to a lawyer, or a lawyer will have to say it depends.
I had one last question to feed off of that is, do parents still hold privilege if the minor is 12 and over and consented for their own mental health services?
Well, and that's again one of those questions that it depends on the nature of the case, and that's true. A child at age 12 can seek therapy on their own. The question then becomes: are they do they have the capacity to be able to assert that privilege, knowing what the consequences are? Remember, capacity is essentially that they understand what the issue is and understand what the consequences might be for a decision that, excuse me, that would be rendered. That's one that I can't answer without looking at the specific facts. So that's, again, one of those things you want to be consulting with counsel.
Another point I'd like to make is this often comes up with schools. And in my experience, because I work at a social work program where we also have interns at schools, if the child approaches our social work intern in the hallway or comes to the office and says, hey, I want to talk to somebody, I have this problem, they can initiate that. But if they maybe the teacher makes the referral, says, I think Jimmy needs to talk to a counselor, the parents have to be involved in that, but kids can initiate it on their own if they approach the therapist themselves. The school counselor, in other words.
I think that's it for questions. Unless anyone has some at this time, they could come off mute.
Well, I see one, Sadie. I see one in there. Can a person who isn't an attorney issue a subpoena? And I don't think so, Seth. I've never had a subpoena issued by somebody who wasn't an attorney. Can you speak to that?
Certainly. The person who is self-represented, if they want to subpoena somebody, they have to go to the court clerk and have the court clerk issue the subpoena.
Thank you.
Yeah, I think that's probably the only exception. I'm just looking at my watch. We're at 10 o'clock. Is now a good time for that break?
Mm-hmm. Yeah, we can take a 10-minute break. Let's see.
And then Sadie, if you have more questions, maybe we could start up with the questions too. So how about, okay.
Not a problem. And then we'll pause recording. 1 second. And sorry about that.
Okay, so we're going to resume and talk more about children and parents in dependency court. Unless, Sadie, you think there's a burning question that we had left over, what would you prefer?
I think there was no more questions at the moment, so we can just get started.
Okay.
Sorry about that. Are you seeing the full screen on your end?
Yes.
The full screen? Okay. Perfect.
Okay, so reviewing the rights of children and parents in dependency court, these are just very overview general information. In the very end, we'll switch to another handout that'll give you more specific information. But important to remember in the beginning that dependency court is a civil proceeding. So a lot of times there's some basic confusion about that and what kind of power the dependency court has. And actually the dependency court, even though it typically doesn't send people to jail unless there's some sort of contempt issue, they have a lot of power because their orders supersede other court orders. And that's important for us to know. It's a civil proceeding and it applies the California Welfare and Institutions Code. And same evidentiary rules apply as in other matters. Supposedly, they are acting in a place of parents and in the child's best interest. All participants in the juvenile court hearings here of dependency court are entitled to an attorney to represent them. So they are appointed in most circumstances. Hearings are held before a judge. There is no jury. So I have experienced when I've gone to dependency court and I've testified in front of a judge, sometimes they allow me to say more things that are allowed to be said in criminal court because the judge is perceived as someone who can handle the information and discriminate appropriately. And so I've been allowed to testify to a lot of things in dependency court. We can remember that county counsel for whatever county you're in represents Children's Protective Services. So that's CPS. Here in Los Angeles County, we call it the Department of Children and Family Services. Other places call it different things. And the question here is, do you need to retain your own attorney for you or your agency as opposed to just working in with county counsel? Because remember, county counsel is representing the Children's Protective Service Agency. And their interest is in trying to present to the court that indeed the child is probably, depends on what the issue is, a dependent child, or we'll get to that at the very end. So you want to think about, do you have an interest in having your own attorney, or does your agency want to retain its own attorney? All of these hearings have specific timelines, but before I get to that, I would like to share that many of the dependency courts are encouraging their cases to go to mediation. And this might be very useful for you as a therapist, because when a case goes to mediation, it does a couple of things. The purpose for the court is to free up some of its docket space or its courtroom space so that other cases can come in. And if the case goes to mediation, only the actual parties involved in the case are with the mediator. And that may alleviate your testimony if they are able to come to some sort of settlement. Mediation can be a very good thing. You can get the parties to agree that they can't have it all their way and there's some sort of a compromise that comes up. And I would like to say that some of the mediators are very skilled in getting the parties to realize that they do have to make a compromise here. And it can be in your best interest as well as the child's best interest. So getting into hearings have specific timelines and burdens of proof and presumptions. I found this wonderful handout created by the Fresno Superior Court. And I think Sadie is going to put that up. And I would like you to think about accessing this if you have questions about specific kinds of hearings. For example, when a child is detained, certain timelines kick into place. And the detention hearing has to be 48 hours after the petition is filed, but in overview, over 72 hours after the child is detained. But remember, those are 72 business hours. So if it takes over the weekend, you know, the weekend is not really business hours. So it can take a little bit longer, but important for us to know if a child is detained, there's always a hearing very soon after. And the question is, did the people with the emergency authority to detain the child, which is usually law enforcement and Children's Protective Services, did they do the right thing at that particular time? Was there an issue about the child's safety? And was there some preliminary evidence that the child would actually be a dependent child? And then all the rest of, if the answer to that is yes, and the child needs to be detained, the rest of the hearings kick in. There's also a possibility that the court could assume jurisdiction and also return the child back to the parents. There's a possibility. But there's a lot of information here, especially on the blue side. And I love this little decision tree graph here. And it really helps you understand what goes on at dependency court. Another thing I'd like to point out, once a kid becomes part of the dependency court and the dependency court takes jurisdiction on behalf of the state of California, there are certain hearings that kick in, and the child is generally reviewed at least every 6 months. There's a hearing. So if you're a therapist, you are often asked to submit a report, or you might be, you might want to know that you could submit something. And there's often, it comes to the court's attention approximately every 6 months. And the court is operating with an eye to permanency. So you will see here at these hearings, you will see a permanency hearing. Oftentimes it won't go to permanency because when family reunification or family maintenance services are offered, they are often ended before it ever goes into permanency. But for some situations, it will go to a permanency hearing. And we should also know that the rules for kids that are 3 and under are a little bit different for the rules for kids that are over 3. And it gets very complicated because sometimes families have kids that are under 3 and kids that are over 3. So sometimes different timelines are kicking in. But I've said a lot of information, so let me pause and see if you can take all that in and see if there's anything that comes up about a dependency court or this timeline that I could answer. Not hearing anything immediately, I'd also like to add that most of our kids, when the issue is child abuse and neglect, they do find their protection at the dependency court. It's a small percentage of cases that make it over to criminal court, but some do, and that's very important. But many cases of abuse and neglect find their initial protection in dependency court. Oh, I see that somebody said a question about mediation. Well, mediation has been big in LA County. Maybe it doesn't happen in every single county. Maybe it happens in, I don't practice over all of California. Usually my practice is pretty much confined to LA County. But mediation, I'm a fan of mediation because I think it gets the parties involved in understanding that we could have a solution to this problem, but it may not be my perfect solution. And I like it as someone who's called as an expert to testify or even a fact witness. It takes the witness out of the situation. Seth, did you want to say something about mediation?
Well, thank you. Mediation is probably, well, let me say it differently. Mediation is a good way to resolve situations where there are conflicts in either the practice of the parents, where there are things that can be corrected, and the people are willing to mediate, you as the professional involved, unless you're dealing with the parents directly, probably won't have much, at least in my view, much to offer in the mediation other than what your recommendations are for the child. But I think the other aspect of this is if there is a mediation and you know that the parent is represented by a particular party and the child is represented by either an individual lawyer or the parent is represented by an individual lawyer, and you have concerns about the child's safety, those are the kind of things that are really important for both that parent, that advocate, and the mediator to know, because that is what's going to either prevent the mediation from being successful or allow it to work through those issues that are literally in the best interest of the child.
I saw something come up about saying, do the parents have to agree to the allegations? Well, okay, so the Welfare and Institutions Code has something all the way from A to J. Is it a physical abuse case? Is it something else? In my own experience, dealing with the dependency court, D is for sexual abuse, and sometimes parents object to the kid being adjudicated as the situation being adjudicated as a 300D. So they may have some controversy about that. And I'm thinking that many times when that happens, it might not go to mediation, because that's a particularly important designation, and that might actually go to a hearing before a hearing officer. And might go initially to mediation, and the mediator might say, we can't agree. And then it would go back to the court for the court to actually have a full hearing on the issue. Any other questions about children and dependency court? Because my sense is that that's mostly what we're dealing with when we're dealing with children and maltreatment. They find some level of protection at the dependency court. And at least I know in our own county, families are much involved with the dependency court. Although there's a push in the Department of Children, Family Services and Children's Protective Services, for other kinds of services, for voluntary family maintenance agreements. You may hear this often, and that's where a family agrees to receive services without going to the dependency court. And usually that has to resolve within a finite period of time. And if the parents are not cooperating with the service plan, then the department has the option of taking it into dependency court, where there will be certain orders issued. But we also have some novel programs to try to, involve entities that might contract with the Department of Children and Family Services. So the Department of Children and Family Services, or your CPS, may not open up a case, but they may send the case to the ABC agency that contracts with the Department of Children and Family Services to see if some perhaps intensive services for a first-time referral may resolve the issue, and the department doesn't have to open up a case. So that is also a possibility that could be happening with cases that you have.
This is probably one of the most common places where you have, as a practitioner, contact with Child Protective Services or the social service entity, whichever that is in your county, because as a mandatory reporter, you're going to have statements made or indications come before you that require you to make that report. Which, by the way, is a whole different subject matter. It could take a day to talk about.
Oh, about mandated reporting. Definitely, I agree with you. We could just take a moment to say it's so important that we, the collective therapeutic community, acknowledge that we're mandated reporters. But if we're all licensed, we all know that, and that came up on our licensure test. But and sometimes in my practice, I see that not everybody, even though they might be licensed, they might not always adhere to their mandatory reporting requirements. And I feel it's very important. I'm a proponent of mandatory reporting.
And as a lawyer, I have to tell you, there's liability if you don't.
Good point. Okay, so if there's no other questions on this one, you know, we can take some in the Q&A later. And good point to know that one of the vignettes will be something that could be run as a dependency court situation, and we could also run it as a family law situation so that people could see what the difference might be. So we could go to the next slide, and Seth's going to tell us about his experience in family law court.
So it's also a civil proceeding, as is indicated here. As far as representation, the only person who's really entitled to a lawyer who most likely will be appointed would be the minor. And if there's a child involved in a very difficult case that requires a whole lot of factual information to be investigated by someone who is non-aligned with either of the parties, then the court may appoint a lawyer for the child. That lawyer is probably going to be paid for by the parties for the most part. The code that is, and remember, we're in a code state as opposed to common law, prevails in these cases, both in terms of most of the procedures and the philosophical view and requirements comes from family code. And that's a specific code separate from everybody else. However, they do operate for the most part, unless it's otherwise stated within the code itself, under the Code of Civil Procedure. So all practices regarding subpoenas, depositions, and discovery are governed by, we say all, for the most part, all are governed by the Code of Civil Procedure. And of course, the evidence code, same rules of evidence apply in these settings. The judge in a case like this is a bench trial in California. Only a judge would hear it. And the judge applies the best interest standard, but it's a very different best interest standard in the context of comparing it to dependency. In dependency is what's the best situation for that child against the entire world. Is the parent protecting the child against influences from outside or bad things from outside? And if not, then we take the child away from that parent if they can't protect and there's an immediate chance of harm. That's dependency. In the family court, it's only between two parents. Those are the only options that a judge has, except under some very basically stringent circumstances, can they consider another kind of placement? And that usually is with another relative. They don't have the power to put a child into a foster home or take them into any other circumstance that involves residency and supervision. Now, as far as the lawyer is concerned that's appointed for the child, the lawyer holds the privilege. So it isn't the parent in a family law matter. And this is, again, another reason why it's so important for you, if you have some inquiries made or subpoenas sent to you in a family case, is to determine, A, is there a minors counsel appointed? Because that's the person who gets to say yay or nay as to whether they can even talk to you, much less get information. And the other is who has legal custody, if indeed there is some question about that. And I maybe breezed over the issue of legal custody previously, so let me be real specific. Legal custody involves the ability to bring a child to a therapist, to get information to a therapist or from a therapist, and to do what is necessary in the best interest of that child to care for that child. So sometimes in family court, a judge will carve out a responsibility for, especially in what cases or where cases have severe conflict and they can't agree on certain things. And because of that disagreement that may harm the child, a judge may order that a parent, A, strictly has legal custody over decisions relating to therapy, healthcare, education, that kind of thing. It may be delineated even more specific than that, as opposed to that broad category. So again, it's really, really important for you to know who has custody, what the terms of custody are, and if you can get a copy of the order, get a copy of the order and a release from the party who's asking for the information. Now, as to your professional role, you may be called as a fact witness. Now, a fact witness means that you have something specific to that case that is relevant to the issues and material to the issues before the court. If you are called as an expert to render an opinion as to whether the child was abused, whether the child should see the other parent, or that kind of thing, you have to be very careful about where you are. Remember, ethically, you can't in essence, make recommendations regarding somebody whom you have not evaluated or interviewed. So for you to come into court and say, ideally, the question will be asked, well, who do you think the child should be with? If you haven't interviewed both parents, that's not an appropriate question for you, and you have to realize what your limitations are. So, in fact, one of the most commonly referred to documents as it relates to family court is a set of guidelines, which is in your reading materials that, or the references, or actually, I think we gave you a copy of it, created by the Association of Family and Conciliation Courts on court-involved therapy. Now, I've looked at it, Colleen has looked at it, a number of other therapeutic entities have looked at it, and we don't agree with everything that's in there because it's oriented towards strictly custody and custody under certain circumstances. It's not law. It's a standard that is a guideline. So it's not something you have to mandate or you're mandated to follow, but it is something you should know about if you're going to get involved in the family court, because if you do any of the things that they caution you against, it likely will create some doubt as to whether or not the information that you're providing the court, or you're providing the child, or you're providing the parent is biased. And that cuts down on the power and the ability of your special knowledge to come into the courtroom and offer helpful information to the court. So it's important to know what those are, especially if the case is in family court. You can decide based on your own both internal policy, your own personal policy, and that of your ethics requirements as to which way you want to go when you read those guidelines. Now, there is often in a family law case where custody is at issue and the judge wants independent information from a neutral party, that they'll appoint a mental health professional to do what's called a child custody evaluation. Now, this is one of the areas where information that you have and documents that you have may be approached or asked to be revealed to the child custody evaluator. Now, the thing about a child custody evaluator is that as the essentially an expert of the court, what is required is anything that child custody evaluator uses, relies on, observes, or obtains during the course of the child custody evaluation is discoverable, because the question is, what's the basis of any recommendations that are made? So this, again, comes to the issue is what's confidential, what can you release, what should you release, what release do you have? And remember, those releases should be very specific. Is it something that's requiring you to talk about what the kid told you? Or is it your information about, excuse me, how many times the child has been in therapy and what your diagnosis is, which is totally separate from the content of the information and the communications. Now, oftentimes people will object to the fact that if you offer an opinion about what your diagnosis is, then the question becomes, what's the basis? Well, what's the basis? The basis is what the child told me. So you have to be very careful. This is one of those tricky areas where if you have any question about whether or not you should be answering a question that addresses those to the custody evaluator or to the court, assert the privilege. Let somebody else make that determination for you, who has a robe on and who has the authority to tell you what is the interpretation of the law. So the custody evaluation, which often takes quite a period of time, would be then essentially summarized in a report, which is then submitted to the court. And the evaluator does have some leeway in terms of the kinds of things that they can withhold as far as what they know. Not necessarily documentation, but not what they know. So if there are some statements that are made by the therapist, which the evaluator feels are detrimental, could cause harm to the child, they may hold that within the confines of their brain and not necessarily put that in writing. The question, though, will always become, and the judge will have to make the determination, is where did this information come from? Is it sound? Is it basic to the issue? And does it support the conclusions that are made? And of course, if the evaluator withholds that information and it's something that's critical, it's going to have to be revealed at some point. You may be asked to do that. If you are asked to do an evaluation, there are specific training requirements. There are specific requirements to the number of evaluations that you perform before you can actually do them on your own. There are a lot of mandatory things that must be done during an evaluation, especially if it is a child custody evaluation involving child sexual abuse. There are specific steps and measures that must be taken. So if you're going to get involved in that area or that arena, or even if someone's going to ask you to do an evaluation or an assessment, you have to determine whether or not you fall within the both credentialed position to be able to do so, or have the experience to do so. And I think that would bring us to the next slide.
Great. So I'm talking about preparing your client for your testimony. And I know that some of the things that are on here are things that we've talked about before, but maybe it bears repeating. So if preparing your client for your testimony was not part of your intake package or your general client orientation, your informed consent, etc., perhaps now you'll want to include it, because I think it protects you on two levels. You know, it protects you against your client, you know, saying I was never informed about this. And the other thing is you want to protect your relationship with the client and at least say that up front. So what I do with my intake proceedings when I was operating with an agency is I would ask a client, you know, so do you understand this? And of course, most people will say, of course I do. I understand it, you know, and they'll say they read it. And you know what? They may have read it. But what I ask them to do is I go, well, let's explain it back to me. How do you understand it? And then you can get into a dialogue about what it means so that the client really truly has informed consent about the possibility of the records having to be given up or you having to also testify about what the client's statements have been. I have to tell you guys, when I have had kids, I also talk to kids about this, you know, and some people say, oh, you do? Well, then they'll never say anything to you. That's true because, you know, as a mandated reporter, you're obligated to tell your clients that you're a mandated reporter, and still people tell you stuff. So I just want you to think about that analogy. It's important to talk about it before it actually happens, because the client feels some sense of, well, maybe they feel the sense of preparation, but most of us are dealing with people who have had some previous trauma. And people who have had some previous trauma, they generally have a trust issue. And so this becomes a trust issue later on. I'm summarizing the points here on the slide that, you know, they might think, oh, here's another person that let me down. Just one more adult that, you know, is not going to help me. So very important that you discuss this upfront ahead of time. And when it actually comes down and you have to talk about the specifics, you have to talk with your client about, you're obligated to take an oath. And what is an oath? A promise to tell the truth. And you may be asked questions about them. You don't know exactly what those questions are going to be. And how do they feel about this? We're very good at eliciting feelings. And it's important to get into a discussion with your client about that. I have found, and this is hard, I found that dealing with children, a lot of children, you know, when I tell them, you know, I may have to go to court and I may have to testify about what they told me, they will come back at you and say things like, well, you promised me that this was going to be confidential. You promised that this was just between us. And the truth is, ladies and gentlemen, I didn't do that, but that's their perception of the situation. So I want you to think about, you know, what is a child's point of view what's their developmental understanding of the process. Because I've had kids really think that we therapists, specifically me, should go in there and really protect the whole record, not say anything about what they said. And sometimes I can assert that privilege, and sometimes I've been ordered to testify, even when I didn't want to. So that's a big decision, and Seth may have something to say more about that. But before we get back to that, I want to say that what I try to do with my clients before I have to go down and testify, I prepare them. I'm going to be asked some questions. I don't know exactly what all the questions will be. I may have to reveal information that you thought was going to be private with me. All I ask is that after the hearing, you come back here and we have at least an opportunity to talk about it, so you can decide if you can continue to confide in me. I don't use the word trust, confide in me. So giving our clients choices about things where they feel a level possibly of betrayal, I think helps restore some level of power to our clients. And I mean both for adults, teenagers, and younger children. So, Seth, do you have some comments on this one?
Sure. We'll go back to the issue of whether or not you're going to be releasing information based on a question that's posed to you in the courtroom. There's a specific case which I often cite, actually, where I'm trying to get information as a result of the need to invade a therapist-patient privilege. In this case, as I recall, it was a psychologist who asserted the privilege, and he kept asserting the privilege from the jail cell until he finally had to be and gave up the defense of that particular privilege. So contempt is a potential. If the judge orders you to do something and you don't, the judge could hold you in contempt. Chances of being sent to jail are probably not very great, and there might be a fine or something or other, but nonetheless, it is something, again, to consider, and that comes down to whether or not you should have your own attorney who can make the right objections.
I'd like to say that many of us have our own malpractice. I do. And as part of my malpractice, I have an attorney that I can consult with. And he or she would be available, on a probably not on an immediate, speed dial basis for that particular moment, but you have to anticipate that this could happen. So I always have access to the person 2 or 3 days ahead of time. And sometimes based on their response from my malpractice insurer, I think, okay, on this one, I think I need my own individual attorney. So I think it's a really important and good idea to have your own malpractice insurance. And I'm sure your agency has it too. And many of you that work for an agency have your own attorney on a consultation basis. And it would be a good idea, as Seth said, to think about where you might get into some issues that might call for you asserting the privilege, and how might you answer those questions.
So we move on.
Do we have questions on this?
Good.
Do we have any questions on this that are coming in through the chat?
I don't believe so, but the next slide is for Q&A.
Okay, so let's move into the Q&A. And so this is a vignette that we might play first as a case that's heard in the dependency court. And then we might be able to consider what would be different if this was a family law case. So you can read a whole lot faster than I can talk. So how about if you, let's take a couple moments and maybe a minute for you to read this paragraph, and we'll give further directions. Okay, has everybody had a chance to read it? I hope. Okay, so the question is two parts. What could you have done differently ahead of time? And then, okay, you're in the moment. You know, the judge leaned in and said, that's enough, Dr. Friend, or thank you very much, Dr. Friend, which is your signal for you're done now. And so part two would be, what can I do at this point as a witness, as actually, I'm both probably a fact witness and maybe I'm an expert witness as well. So Sadie, could you take us off from the questions so we could see everyone, so we could have a little bit of a discussion? What do you think that you may have done differently, you know, maybe a couple of weeks before you actually went in for this testimony? Anybody?
I'll just read one of the things in the chat. It's absolutely true, is that this scenario is very common because it's difficult to reach the attorneys at any time when you're working because they're in the courtroom or otherwise.
You know, Seth and I talked about that. We were actually laughing because, you know, when the way the courtroom works is actually in the dependency court and probably many courts around there, the first part of the day in the morning, they're calling calendar. So the county counsel is generally in the courtroom and cannot speak with you, you know, between whatever it is when they start 8:30 or 9 to noon. And then if you know how the court operates, they generally take, I know, an hour for lunch, you know, from 12 to 1:30. So you're trying to call the attorney, unless you have their personal cell number, you're calling them at their, you know, maybe in the courtroom or their office, you know, they may be out to lunch. And then court resumes around 1:30 and they may be in a contested court hearing in the afternoon. So you do, I'm so sorry to say, in me, I say the vigilance belongs to me, and the determination and the follow-up belongs to me, and I have to try several times. And sometimes that means involve leaving messages and leaving my own personal cell number so that person can maybe reach me when he or she is available. So yeah, I agree with you. It can be problematic to reach that attorney. So given that, you know, I think the answer is, you know, I should try to reach the attorney, and I should maybe give myself 2 weeks to be able to do that. What do you think you could have discussed with the attorney ahead of time?
Who's brave enough to offer something?
Probably the symptoms you're seeing.
That's very good. Selena, I like your answer. So probably you should call the attorney, give yourself at least 2 weeks to get a hold of him or her and discuss the symptoms that you're seeing. And maybe the reasons why you think this kid may have what we call complex trauma, you know, and as Seth said earlier, don't assume that the attorney knows what you know. Like, how do you define complex trauma? Why would you think that this kid might have this? What are your reasons why you think the kid should stay longer than this 6-month period? It's always a good idea to use standard measures, you know, and to see how the kid is doing and how the kid is making progress in your therapeutic relationship. And what these standard measures do is they allow you to testify, you know, the kid received perhaps this score on the trauma symptom checklist. If you're using that, then you could say, okay, 6 months later, this score. I'm wanting to keep the kid in therapy because I don't want to release the kid until it looks like there's some resolution of these issues, or the score would be at X, whatever you say X should be. So thank you, Selena, for saying that. So talking about what you see, the symptoms you see, why you think the kid should remain in therapy, maybe your discussion of standard measures, that would all go into your discussion with the lawyer ahead of time. And how about this other thing we talked about? You may need to think, do I need my own separate counsel on this? Do I? Question. I don't know. But talking to the attorney ahead of time would give you hopefully a better chance at this attorney, just that the county counsel can only say, why do you think Jared should stay in therapy longer, the county council would be prepared to come back and expand your testimony a little bit further.
So probably
Okay, so that was part one. Part two, Seth, did you want to say something? Go ahead.
good. There's another aspect of this. It could be in the dependency court. It could be in the family court. If you're basing your opinion on what's best for this child based only on what the child has told you, that's probably a fairly good basis to at least begin. But the other question is, what other information have you obtained? Did you only talk to mom? Did you only talk to dad? In terms of what they have told you and what you see in the kid, is there something that leads you to the conclusion that you've reached? Balance is a very critical factor in these cases, and it's always important to be able to say that you at least tried to contact the offending parent who or the person who's accused of whatever it is that's happening, and so that you can come into court and say, well, I tried, I called, here's my email, whatever it is that you have tried to do, and initiating that contact to get a balanced view of what's going on with the child. That's one of the most common attacks that happen to a mental health professional who is working in a case where the family court is involved. Bias is one of the chief ways of discrediting and otherwise minimizing any opinion that comes from a mental health professional. By the way, the other thing you could do is leave a cell phone and be willing to talk to the lawyer after hours, because that's when I worked for the DA's office, that was almost invariably our calls were returned after 5 o'clock.
That's a very good point, Seth. I find that that's true too. When I leave my cell phone, I'm often called in the evening, and then I'm willing to talk to attorneys in the evening because I know that's oftentimes they can't do it while they're engaged in another case and in the courtroom. So part two of that question was, okay, so we say, good idea, give yourself a 2-week head start, a week to maybe, return phone calls and phone tag and so forth. The next week to actually get an opportunity to talk to the attorney about what you're seeing with the child and what your reasons are for the child to remain in therapy. But point number 2, let's say in the moment, the judge has said, thank you very much, and sort of signaled to you that you're done. And you're thinking, synapses, fire. What can you do? What can you do in that moment? Anybody have any ideas?
How many of you have been in that situation? Raise your hand. Very hard to do when you only have his names here.
Yeah, maybe that's a hard one here. So anybody want to say if they've been in that situation, what they ended up doing? And sometimes, the situation you're in is like you don't know what to do, so you just kind of resign yourself to it. But Seth and I have a few ideas about things that you might be able to do if you still want to hang in there a little bit more and say more. Like there have been, when I've been in that situation in dependency court, I've turned to the judge and I've said, Your Honor, there's still one more important point I'd like to make. Am I allowed to make it? And so oftentimes the judge will say, okay, or the county council will say, Your Honor, apparently the witness has one more important point to make, and it will ask on my behalf if I can make it too. Seth, do you have a comment on that?
Yes, I think that's a very appropriate thing to do. Usually what the judge will say is, well, there's no question before you, but that's a cue to the lawyer who's asked the question in the first place to do exactly what Colleen has just mentioned that the lawyer should do. There are other things that you can do is when you start your recitation of what it is that you're talking about, remember that testimony is something that's supposed to go in a question-answer format. So when you get into what's called a narrative, meaning that you're talking about a whole bunch of different things that may involve objectionable information, meaning that it's hearsay or it's inadmissible for some other reason, the objection might be, you finished. I think the formal objection would be calls for a narrative, or she's gone beyond the question. That doesn't mean you have to totally give up on what it is you're saying. That's the cue for the lawyer who's asking for that information to come back and say, well, what else is it that you had to say? Or in the beginning, you can think about maybe 5 or 6 different points that you want to make, and you can tell the judge in the beginning, well, there are 6 things that I've considered that I think are really important as to why I came to this conclusion. Or there are 6 things that go into, be it called factors, be it called symptoms, be it called syndromes, whatever it is, that support what it is I have to say. And you take them one at a time. Now, what's going to happen is that once you get past one, they're going to ask you, and you should stop, pause, let the attorney then ask, well, what was the next one? You said there were 6. What's the second one? And you give them a path by which they can lead the discussion, knowing that you have more information. One of the other things that you can do if a judge has said, well, sustains the objection on narrative basis or whatever, is simply say, well, I have 5 other points that I need to talk about and that are really important, and stop it there. That's the cue for the other lawyer to come back and ask you that question, those questions.
I hope that's helpful to you, that even if you haven't prepared with the attorney, sometimes when you get into that quandary, there can be some things you can do in the moment. So I hope that this training has been helpful to give you that repertoire of possible tools that you might be able to use. But again, it all goes back to preparation with the attorney.
Let me add one thing to that. The important part and role that you play is that you have really significant information that a court wants to know. And it's important for you to come across as the expert, the person, if you're being called as an expert, or you're being called to render an opinion of any sort regarding the child that you're dealing with. So you want to be, first of all, we talked about this earlier, professional. Secondly, you want to be authoritative. And lastly, you want to make it appear as though you are as neutral as you can possibly be, as opposed to an advocate for a particular position that you want to profess, be it for one parent or the other, or even for the child in that sense. Whereas, the responsibility of most therapists is to do what's in the best interest of their children or their clients, and to advocate for those clients. Here, advocacy simply means to provide information, and provide it in as neutral a way as possible, as opposed to, I think this should be done, and emphasize certain things, because that's the kind of thing that, again, goes to a bias, which then may end up minimizing the power and the ability of you to convince the court of what is best for that child.
So, Seth, if we took this case and we ran it as a family law case, and let's say we have some divorcing parents here, and what if we changed it a little bit and we said one of the parents says therapy should be terminated. The other parent is saying, oh, I'm okay if it goes, I want it to go for the full length that the therapist wants it to go. How do you think it would be different?
Well, let's turn that to the audience to see what experiences they've had that way, because I think there are definitely some differences in terms of how that case could be handled. Has anybody been in that situation in a family court? So in the family court, remember, you have 2 advocates on either side. Depending on the nature and personalities, some will be more willing to try to do things in a way that is less adversarial. But if it's gone to trial, you can pretty much assure that the 2 attorneys are going after each other's case in an aggressive manner. So here, once again, your neutrality is really important. Remembering that you'll probably be marshaled by one or both of the parents for your opinion. They're going to provide you information which it could be helpful in terms of dealing with the child that you have, as well as they'll want to know about, well, gee, my child's exhibiting this information or this symptom or this behavior. What do I do? And again, in documenting your conversations with those individuals, you want to be clear about what it is that they've asked and what they've said, what they've tried to push you in a direction if you feel that that's what's happening, and your perceptions about whether they're being overly aggressive or not probably are not going to be admissible. So you want to be factual, simply about what they said. Use the words that they wrote. Be very careful in your notes to be clear about when the conversation happened, how long it went for, and what specifically they said. Be detailed as detailed as you can. Under these circumstances, you're going to have parents who don't agree with whether therapy is appropriate or not, because many reasons may motivate them to want to protect the child from intrusion, which they think are going to be harmful for them. Some people don't particularly care for therapy. And then you have the other people who don't want therapy or don't want somebody to talk to their kid because they're afraid of what they'll say, because it's got some negative consequences for them, especially in sexual abuse cases. So it is really critical under those circumstances to be very careful about how you assimilate the information and then how you present it. If you believe that the child is at risk, if the child has made statements that indicate abuse, you must report it. Too often what happens is in family court is the therapist will be working with the child. The child will continue to make statements even though CPS has investigated the case and decided that there wasn't something that they could act on, and you make the report and they don't act on it because they what's called evaluate it out because it's been previously investigated, or those statements they believe have already been made. But it's still important for you to make those reports regardless of whether they act on them, and to what degree that you go to get the CPS worker, whoever it is that you talk to do further investigation, also sometimes bears on the nature of your advocacy. And so you have to be careful about what you say, how you report it, and to whom you speak about those things. Those are the important parts of a case like this. Usually where parents disagree, it's ultimately it's going to be the judge who makes the determination. And you want to be able to give the judge as sound a basis upon which to rule as you possibly can. And that goes to all the things we talked about in terms of preparation, the information in your file, the manner in which you've consulted with the attorneys who have or who are going to be putting on that evidence, and of course, in rendering your opinion.
Okay, so are there any further questions? Because we had another vignette, but we'd rather answer your questions and be, responsive to whatever it is you wanted to know. And we could give a short, I could give a sort of a bit of a wrap up here about what Seth and I were communicating about, and then I could turn it back over to Sadie. So any further questions? Or just comments about what we talked about?
I have a question. If both parents have legal custody or neither have it written in, like, no actual custody orders, and we see this often in domestic violence cases, do one or both parties have to consent, or is one party fine for that?
Well, again, that's one of those questions that is a little bit of, it depends. Domestic violence is by itself child abuse if it occurs within the presence of a child. So that's a mandatory reporting issue, number one. Number two, if a parent makes a request for information or takes the child to a therapist, if there's no order at all about who has custody, then either parent has the right to take a child to a therapist. Now, there's some ethical considerations which govern this as well. Now, I'm talking about the legal parts of whether or not you can do that. And there's a major case right now in the system that I'm aware of where that was just the very issue as to whether or not the therapist had the authority by which to act on it and to do anything with the child. And it was a question about what really is an emergency. So the situation depends on a couple of factors there. If you feel the child is at risk and needs to be talked to or whatever, based on what that is, if there is no order, and how do you assure that that's the case, remembering that parents are not always honest with you in terms of what their positions are, or they're honest but they don't understand and they're trying to give you what they think the rules are. So it's not always a malicious or malignant answer that you're getting. The parent who brings the child does have that authority to bring the child to you if there's no order. Now, if there is an order, it depends on, as I said before, what the nature of that order is. If it's a matter of the parent having only the authority to do one specific thing and the other parent doesn't, then that could be a problem. As far as bringing the child to the therapist, and I'm assuming that that's what that question is addressed to. Domestic violence therapists and advocates, of course, have their own privilege between communications with both the parent and even the child under those circumstances, if they are and would be a victim of domestic violence, if they're in the presence of the commission of any violent act or even what's now called coercive control. So, those are the things that you need to be thinking about in terms of who brings it to you, what the nature of it is, and how do you establish that in your mind that that's what's going on. Obviously, in domestic violence, it's some urgency, and you may have to act and do things quickly without having all the information. And again, it depends on the circumstances.
Okay. Can I give a brief recap of what it is that we did today? Okay, so we opened up with talking about, I think there's actually 5 things, I counted them up. So modeling what Seth said before, if the judge says, thank you very much, Your Honor, there's 5 important things that I really think need to be discussed here. So the 5 things I think we had up today. We talked about subpoenas and how to respond to them. And then we talked about the confidentiality privilege, and that belongs to the client, but you are in charge of asserting it on behalf of the client. We talked about what you would do if that comes up for you. And we actually talked about, let's see, the fact versus the expert witness. And one of the keys between the two is that an expert witness can actually give opinions, and that's different from a fact witness. And then the 4th thing is we talked about the differences in family law court as versus dependency court. They're both civil courts, but they have very different orientations, maybe not completely different. They have different procedures, and we had a handout for you to look on specific information on the dependency court. And then we have a reading list, and we also have the report, that the guidelines that Seth referenced about the family law court. And that might be important if you're getting involved with family law court further as persons who are offering testimony or just wanting to understand the guidelines for their interactions. And lastly, we talked about how you can prepare your client for you having to testify about the adult or the child, and that this is really important to do ahead of time and ask them to come back at least one more time to process this and see if they can continue to confide in you. And we hope that all this information we gave you today might give you some reason to think about, should I be revising my intake procedures so that I can definitely talk to my clients ahead of time so that they might know that this is a possibility and what they might expect. And then if you're doing that, you want to make sure the client really understands it. So ask them to explain it back to you so you can actually get into a discussion. Seth, did you want to add anything to that wrap up?
No, I think you did a very adequate job, and just thank everybody for attending. And if you have any other questions, I think our contact information is in the materials that you have. And feel free to give us a call. I'm sure that we'd be glad to do as much as we can within both ethical and legal constraints, answer your questions.
Thank you.
Thank you,
so
Seth. And I'm going to
much.
turn it back over to Sadie for a wrap up and comment. Thank you.
Yeah. Thank you so much, Colleen and Seth, for coming today and presenting. We really appreciate it. And for all of our participants, you will be receiving a follow-up email with the recording, the PowerPoint slides, as well as all the supporting documents that they have presented today. We have just a few quick announcements. Brittany, if you can bring up the slides. But coming up next month, we are going to be having our Let's Chat on December 7th at 9:30. And I believe Brittany will put the link to register in the chat. We will be having just a brief follow-up with Dr. Colleen with any questions that come up. And we will also have some announcements and OES updates, as well as opening it up for our community of practice and having some discussion questions with our other organizations. We will then have our holiday breaks for everyone, and so we will have our next advisory committee meeting coming up in January, and then following that up with our winter symposium in February. And then next slide, I did put in my contact information just in case anyone would like to reach out if they need any support or have any more questions for me. And lastly, I wanted to thank our advisory committee in partnering and collaborating with making this symposium happen. So I hope you guys have a wonderful week, and thank you for spending your morning with us.
Sadie,
Yeah.
can you speak you had on your list the needs assessment calls, and if anybody in the event today is one of the leads for their agency, it'd be good for them to know more about this. And I'll just take a moment to also to thank our funder, Office of Emergency Services. But yeah, if you want to speak to that really quickly.
Perfect. So yes, for our needs assessments, I am reaching out individually through emails to get this set up with you within the next 2 months. But you'll be receiving that email within the next 2 weeks to set up a time that works best for you. I know that timing is hard with the holidays, but it should be a brief 15 to 30-minute meeting just so I can better understand your needs and what you would like to see going forward. All right. Were we at, oh, perfect. And the link is in the chat. The link is in the chat for the Let's Chat meeting next month. Thank you guys. Have a wonderful day.